Kim Stone with the Civil Justice Association of California. I'd just like to talk briefly about our state's legal and academic support of arbitration as a fair, efficient, and cost-effective method of resolving disputes. The California Supreme Court has supported the use of pre-dispute arbitration agreements to solve complaints. While there's not a case on point in terms of the CEQA and environmental law issue, the Supreme Court has held that fair employment and housing claims are arbitrable in a case called Armendariz versus Foundation Health Care Services. Also, in a case called Grafton Partners versus Superior Court, the court emphasized its support of arbitration agreements as a way of resolving disputes. Academics have also noted that arbitration is a fair, speedy, and efficient way to resolve problems. Again, while I don't have a study particularly on point in terms of CEQA, primarily because I think they haven't used arbitration for CEQA, a Stanford Law Review empirical study of arbitration and employment law concluded that from the employee's point of view, arbitration yielded roughly the same result of litigation, but it was faster, and in fact, sometimes employees felt like they had gotten their say greater in arbitration than they did in litigation. And also the Northwestern University School of Law Searle Center on Law, Regulation, and Economic Growth reviewed 301 cases of consumer arbitration and concluded that the upfront cost of arbitration for consumer claims was much lower than in litigation. The average time from filing to resolution was much lower, and there was no bias in favor of the business through a repeat player effect, even though they were paying for it. So because the California courts and academics have supported arbitration, and because it is a fair and efficient means of resolving disputes, we support this bill and urge your aye vote.